Hi, good day. In the last presentation, we have discussed about a landmark judgment of the Honorable Supreme Court with respect to the rights of home buyers in the Insolvency and Bankruptcy Code. In continuation to that, I am today analyzing another recent judgment of the Honorable Supreme Court of India where the bench had analyzed whether the pledge of shares by a third party constitutes financial debt under the IBC. This particular analysis was made by the Honorable Supreme Court of India in its reportable judgment of Vistra ITCL India Limited and others versus Mr. Dinakar, Subramaniam and another. It is civil appeal number 3606-2020, order dated 4th May 2023. So the facts of the case in brief. This is a case with respect to the Amtech Auto Limited, which is a corporate debtor who had approached Vistra ITCL Limited to extend the loan to its group companies, namely Brasco Engineers Limited and WLD Investment Private Limited. The amount was for the ultimate benefit of the corporate debtor, that is Amtech Auto Limited. The corporate debtor agreed to create a first-ranking exclusive security by way of a pledge over the equity shares of JMT Auto Limited, which is called pledged shares. Accordingly, security trust agreement was executed with the NOC of other major financial creditors like IDBI Bank. Subsequently, CIRP application under Section 7 was admitted against the Amtech Auto Limited, and Vistra, that is a lender, had filed a claim as a secured creditor and submitted his claim in Form C, which was rejected by the resolution professional at that stage. And subsequently, the resolution plan was approved by the COC and adjudicating authority, but which was rejected at later stage to the non-fulfillment of the conditions by the successful resolution applicant, and the matter went again back to the COC. At that time, the Vistra, that is the lender, had again claimed the right on the basis of the pledged shares, which NCLT and NCLAT had dismissed. The said order led to this appeal before the Honorable Supreme Court of India. The questions before the bench in this case was that whether the pledge of shares constituted financial debt under the IBC in view of the definition of the security interest as defined under Section 3, subsection 31 of the IBC. That is the first question. Second question, whether the decision of the Honorable Supreme Court in India in two judgments, one is Anu Jain IRP of JP Infra Limited versus Axis Bank, and second judgment, Phoenix ARC Private Limited versus Kedul Bhai Ramu Bhai Patel, be binding on the present case. The third question, whether there is a creditor-debtor relationship between the ledger, who is a pawnee, and the pawner, that is Amtech, which is the ultimate beneficiary of the loan account. So these are the three questions before the bench. So we will have to see what was the judgments of the Honorable Supreme Court is Anu Jain matter and the Phoenix ARC. So we will see the Anu Jain matter first. What was the conclusion by the Honorable Supreme Court of India? In that case, the issue was whether the lenders of the holding company would get the status of financial creditors in CIRP initiated against the subsidiary company. That was the question. The distinction between financial creditor and secured creditor was detailedly analyzed in that particular judgment. Financial creditors are the only stakeholders concerned and concomitant to the resurgence and restructuring of the CD. That was the observation of the bench at that time. Secured creditors may only have an interest in realizing the value of the security and therefore will not have a stake or interest in the CD's revival or equitable liquidation. That was the observation regarding the secured creditor by the bench. Therefore, it was concluded that a person who has only security interest would be outside the scope of the definition of the financial creditors and consequently outside the scope of the COC also. That was an Anu Jain matter. Now, in the Phoenix ARC Limited, the facts was that the name of the CD was Doshian Velolia Water Solutions Private Limited, had pledged its investments in another company as a security for the loan availed from L&T Infratech. A separate agreement was executed with L&D for the pledge of shares. L&D later assigned this debt to Phoenix ARC, who had filed the appeal before the Supreme Court of India. The court analyzed the difference between pledge agreement and a contract of guarantee in that particular judgment. A contract of guarantee contains a guarantee to perform the promise or discharge the liability of a third person, whereas a pledge agreement is not a contract to perform or discharge the liability of the borrower. Pledge agreement is limited to pledge the shares as a security and not a promise to discharge the liability of the borrower. That was the observation of the bench. Our shares were pledged to L&T. The same shall not constitute financial debt and Phoenix shall not be a financial creditor. That was the observation in this particular judgment. So, based on these two judgments, the bench had, in this case, came for the following observations. The persons having only security interest over the assets of the CD is a secured creditor. But said secured creditor is not a financial creditor within the meaning of section 5, subsection 8, clause 7 of the code. So, in this particular case, Amtech Auto Limited was the ultimate beneficiary of the loan availed from this lender. So, bench had analyzed whether this usage of funds have any relevance to determine whether that particular company is a secured creditor or a financial creditor. In the case of, the court observed that the Amtech used the funds. The liability of the repayment was still with the borrower, not with the Amtech. Amtech is not liable to repay the loan advance as per the terms of this agreement. So, bench had further analyzed the law of pledge and detailedly analyzed the provisions of the Indian Contract Act, specifically section 172. It states that pledge contemplates special rights for the pawnee in the goods pledged. One is a right to possession of security, a right to bring suit against a pawner, and right to sell goods after giving reasonable notice to the pawner. So, what is the status of the pawner? The bench had analyzed that factor also. Vistra is to be treated as a secured creditor, as it does not fall under the category of financial creditor or operational creditor. It suggested or directed to treat the Vistra as a secured creditor in terms of section 52 and 53 of the code. Vistra will be able to retain the security interest in the pledged securities. And bench also directed that Vistra would be entitled to retain the security proceeds on the sale of the said pledged securities under section 52 of the code, read with the rule 21A of the liquidation process regulations. So, thank you very much.